Mr. Speaker, Titles 3 through 6 of the bill purport to settle 4 water rights claims against the United States by signing away the public's right to nearly 300 billion gallons of water every year in perpetuity, in addition to spending more than $1 billion. Now, the proponents of the bill are correct that if the taxpayers are going to end up paying more if these claims go to trial, then we should settle them out of court. But that's simply not the case. For the better part of a year, I asked for a legal opinion from the Attorney General on this question, to no avail, until a day before the issue was first brought to the House floor. And what we received was not a legal opinion assessing the validity of the claims or the extent of the taxpayers' liability. It was a general statement of their preference for settling claims rather than litigating them, and it is undermined by very many specific objections raised by the administration over the course of the last 2 years. For example, with respect to the White Mountain Apache settlement, the Department of Interior wrote on November 15th of this year, quote, "This authorizes federal appropriations for numerous tribal projects that are extraneous to the settlement." And they urged, quote, "These projects should be considered on their own merits in separate authorizing legislation." Last year, it warned that funding would, quote, be excessive if it were viewed as settlement consideration. They also warned a year ago of language that is still in the bill, which waives the sovereign immunity of the United States for future litigation. They warn, and I quote, "This provision will engender additional litigation and likely in competing state and federal forums rather than resolving the water rights disputes. Engender additional litigation, extraneous to the settlement, excessive if viewed as settlement consideration." These are the administration's own words. In fact, the administration expressed so many reservations about aspects of these settlements that we can only conclude that they are not settlements negotiated by the Attorney General and presented to the Congress, but rather they are a grab bag written by the Congress itself and now rubber-stamped by the administration on political and not legal grounds. We were initially told that the Attorney General never comments on the validity of claims, but we found this to be false. For example, in the Colville case in 1994, when the Attorney General's office believed that we needed to settle out of court, they said so. They said that we're, quote, "not well postured for a victory on this claim." They warned, quote, "the outcome could easily be a significant cost to the taxpayers and the public," and that is not what they're saying now with respect to these 4 settlement claims. Mr. Speaker, we have many more Indian water settlements pending for vast quantities of water and substantial sums of money. We need to get our act together on this. I believe Congress needs to demand that the administration be candid and forthcoming on all claims for settlement, and that Congress insist that before it begins deliberating on a settlement, that the Attorney General has conducted and completed the negotiations, determined all of the details, certified that the settlement is within the legal liability of the government, and only then submits that settlement for consideration by Congress. Anything less is breaching the fiduciary responsibility that we hold to all of the people of the United States, and I reserve the balance of my time.
Gentleman reserves balance of the time. Gentleman from West Virginia.